that it is important to note that whereas Uhuru Kenyatta, William Ruto, Joshua Arap Sang, and the others who against whom the cases were dropped were charged with the most serious offenses, did not receive warrants of arrest. They received summons.
Which is what Walter Baraza is trying to argue for.
Indeed. We now have warrants of arrest against individuals for witness tampering. I think for me, that's something important that my brother here needs to think about, that for more heinous offenses, there were summons issued. For less heinous offenses, warrants of arrest have been issued. That can't be something you take for granted.
Okay, Elisha, would you like to weigh in on this issue of witness tampering and where it goes? Because it seems like the two are separate. Or are they?
There are two aspects that I think I need to clarify in respect of Mr. Omari's position. One, the question is whether or not it will be prima facie evidence of witness tampering. And a court of law has issued warrants of arrest against not less than 3 individuals in relation to witness tampering. Now, warrants of arrest are not issued for fun. Warrants of arrest are issued when there is some material on record to show that there is a pointer of that direction. There must have been a pointer on the material presented before the judges to show that on the face of it, there appears to be prima facie evidence of witness tampering to warrant the issuance of the warrant of arrest. Mr. Omari also describes the International Criminal Court as not being a criminal court. I mean, conceptually, that deserves further elaboration because, strictly speaking, the International Criminal Court, as the name suggests, is a criminal court. It's a court established by a statute that describes it as a criminal court. It tries individuals on allegations of commission of crimes and therefore to try and politicize the court in that context by describing it other than a criminal court is to miss the point. But let me come to the position of the appeals chamber on the question of tampering of witnesses. The question that was before the appeals chamber, in my humble view, was a limited question. The limited nature of the question was whether or not Rule 68 could be applied retrospectively. And my reading of the court's judgment is that it limited its answer on that particular question of whether or not the rule applies retrospectively, and the court found that the rule was not applicable retrospectively for reasons it has set out in that ruling. So that the question of witness tampering, although a live question in the general context of the proceedings before the International Criminal Court, was not available, was not one of the questions that the appeals chamber was called upon to answer in the limited circumstances, in the limited context of the question that was framed for it to answer, whether or not Rule 68 could apply respectively, in this case, to the Kenyan cases.
Okay, and thanks for that clarification. So let's talk about what would possibly be going on within the trial chamber at this moment, because if you recall, when the trial chamber was making a judgment or a ruling on this issue, Judge Osuji had a dissenting opinion, did he not? And he spoke of the use of 69(3).
Yes.
Would this affect the dynamics of the trial chamber? For a layman coming into this process with Judge Osuji telling his counterparts, I told you so, now that the appeals chamber has upheld or has overturned that decision?
Yvonne, I think the issue really, probably we're being too technical about the rules. The point is that there was a Rule 68, there is a Rule 69(3), which also would permit admission of the nature of evidence that the appeals chamber already declined, that Rule 68 would not be the applicable one.
Do you think that's something Fatou Bensouda can use now? She closed her case, but can she use Article 69, which, case, by the way, is to allow all evidence to be used in terms of trying to get to the truth?
That is a rule that allows the court to apply its discretion to say, can we look at the evidence that is available? So it's for the court to say, we want to look at this evidence or the other evidence. I think for purposes of criminal justice, and there are two elements of the criminal justice, that the criminal justice for the victims of the crime and for the subject or suspect of the crime. for purposes of the criminal justice system, it is the court to determine whether it really would like to admit that evidence, but it has got to be moved. Now that already Bensouda has closed her case and already applied to use Rule 68 rather than 69(3), I do not expect that she will be applying to say, now that I have failed on this front, let me use the other front.
Yeah, picking and choosing and that sort of thing.
Exactly. But the point is that we have also seen before convictions, or may I say a conviction, based on the evidence, critical evidence of one person, one witness.
Charles Taylor.
So that the Charles Taylor case. So that it is not, it's not time for, in my view, for anyone, whether William Ruto or his supporters or those who oppose them, to celebrate one way or the other that we have avoided a conviction. What is important for me is to look at the case and say, in the totality of the circumstances, looking at what happened in Kenya, what happened to the victims of the post-election violence, what has happened since up to now, since 2008, and this is 2016. Yes. It's about a decade, in another 1 or 2 years. Right. What will have happened to the victims? What will have happened with the circumstances that led to the post-election violence happening, and what is it that is likely to happen?
Let's let Danston weigh in on that. What happens now to the victims?
Before I talk about the victims, I'll respond to Ongoya, who was my senior lecturer, that why I call the ICC not really a criminal court, a serious criminal court. There's no court, a criminal court worldwide that can apply any law retrospectively. That is the purpose I'm saying.
But I think they've already ruled on that matter, and we've crossed that bridge.
I've answered my senior that.
Right.
Two, when we talk about the victims, I really sympathize and pass sincere sympathies to Kenyans who suffered during the post-election violence. They are brothers, they are sisters, they are mothers, they are fathers. It was quite a horrid experience. But the question I'm always asking, just because Kenyans suffered, just because people were displaced, just because people were killed, do we prosecute somebody who is not part and parcel of that anarchy? That is the problem.
Should we let the courts decide that, though?
Yeah, we let the court to decide that.
Because it sounds like you're making a judgment on their guilt or innocence, and that's for the court to decide.
The question I'm saying, Bensouda came to court and clearly stated she does not have enough evidence. She went fishing for recanted evidence. That, to me, is an admission, and I've said it is not the first admission that leads to a withdrawal. This is the second admission, and that is why I'm very opportunistic that definitely she will go for a withdrawal.
All right,
the only biggest problem that we have is that the ICC was created to defend the people of, just like our Kenyans who suffered during the post-election violence. The office of the office of Ocampo failed to do its mandate. Investigate properly, nail the people who caused that, and take them to the ICC. So now where we are, and my seniors, I'm appealing to my two seniors that the only alternative is, do we again, does the court order for a reinvestigation of who caused the post-election violence? If that direction comes that way, then we'll have justice.
I will answer you quickly, very, very briefly, to say, one, under the rules, the prosecutor has not made the election not to continue investigations. So we expect that the investigations ought to and should continue going on. Two, it is not right to say that those who are prosecuted on account of whether we support them or not, that therefore, especially if we support them, that they are not responsible. What I have been urging, including the president, his deputy president, and others, that let the due process of the law follow its course, so that we know the truth, because the truth is important. Even without a conviction, the truth is important, because then it brings closure to a subject that is as traumatizing as the one that we are facing.
All right, Elisha, let's talk about justice for the victims and whether this is found at the ICC, but I'd also like your comment on what's happening locally in terms of finding justice for the victims, because that is the ultimate goal, is it not?
Yes, Yvonne, I agree with you entirely that the worst loser in the whole of this context, in the whole of these struggles, is the question of justice for the victim, whether or not the prosecutor is right or the defense is wrong. Because, again, let me not be misunderstood for suggesting that the particular accused persons in this case must be convicted at all costs. That would be a wrong approach to criminal justice jurisprudence. Every person who is brought before the law is entitled to a fair process, and every person who is brought before the law is entitled to secure protection of that very law. But at the end of the day, whichever way we implement this law, we give effect to this law, we must know that they are real flesh and blood victims of these circumstances that befell our country at that point in time, who are waiting for answers. Who did this to us, and why? There are just two side issues that I wish to mention. Number one, to clarify for my colleague Mr. Ndubi on whether or not Ruto or Sang has a reason to celebrate. They, of course, have a reason to celebrate, because the prosecutor was not seeking to use this recanted evidence for fun. The prosecutor must have had reason to believe that these recanted pieces of testimony or pieces of evidence have some value that it adds to her case, and to that extent, that value must be lost. And being on the opposite side, obviously Mr. Ruto and Mr. Sang have reason to be happy that the value that the prosecutor desired to add to her case by use of this evidence is lost. But that celebration, to answer my colleague Mr. Omari, must be limited celebration. As we saw in the Charles Taylor case, out of I think about 44 witnesses, about 41 withdrew, and the evidence of 3 was regarded, and only 1 was found to be compelling, and that one witness, Charles Taylor, was convicted. So I think it's too early to engage in full-blown celebration by the accused person as well, considering that as we speak today, the prosecutor has not made up her mind that she's going to withdraw this case. And being the experienced prosecutor that Mr. Omari referred to, there must be a reason why she's doing that. That's not to suggest that she's going to severe conviction, but she must have evaluated the results of the evidence and seen that let the matter move on to its logical end in terms of the judge's determination of the motion that is now pending before it. As a country, that gives us reason to be very pensive in our reflection, that we did not set up any meaningful local mechanism to deal with what befell this country in 2007-2008. We have attempted a use of the international criminal justice infrastructure, and we don't seem to be realizing any meaningful answers to the victim. The challenge is that this may culminate into a justice gap. A justice gap is a situation where something that requires redress by the law has occurred, and that the law has not supplied an answer to that.